we may not be able to know the extent of relationship or similarity of the facts, because decisions are taken based on facts and with the applicable law, the correlation between such or those set of facts with the applicable law. Now, it is the affidavit that they filed in court that definitely would determine, and that is what the court will rely on to come to a particular decision, which I am not privy to at this moment. But to the extent of what we know, that yes, both of them took part in, like you did say, in a certain nomination, and then went back to allegedly or a contest that they took part in another election. But one thing is clear, that for this matter to have been to the court, to have been taken to the court by the relevant parties, there must have been a cause of action, especially on those the applicants or the plaintiffs. One, because another fact that is known to us is that there are other persons that be nominated by the political party, in this case the APC, according to section 29 of the Electoral Act, and their names submitted, to the electoral umpire INEC, and then before this other gentleman came up. So the law is very clear that if you have to change the nomination, it has to follow, being consistent with section 33 of the Electoral Act, whereby the nominated person either withdraws or dies. And in both situations, beyond this, the political party, the word is shall not. That the political party, no political party has the right to change a nominated person, or in this case, that is a candidate for a political party, after a valid nomination. And a valid nomination, it would be through a primary and all that. So conducted in line with section 29. So I would say that the courts, being abreast with the facts, knows why the court to decision differently, and that is it. And I want to state, having stated that, I want to say that in any situation, there is this standard principle that no set of facts are exactly the same. There would, to a great extent or to a certain extent, some dissimilarities, and that is the extent to which decisions that a particular court arrives at in such similar but still dissimilar situations may vary. So that might be that in this case. However, even when the similarities may even still lead to the same decision. So like I said, it all boils down to the extent to which, as we all know, the primary law in respect of this kind of situation is the Electoral Act. So depending on the extent to which the case of the other person nominated in Akpabio, it's possible that his nomination, according to the facts stated before the court, may have certain digression from being considered a valid nomination in line with the Electoral Act. It's possible. And then it's also possible that in the case of Yobe, the other gentleman, Machina, Raj Machina, because what it means is that his nomination is considered valid by the court, the appellate court. And when his nomination is valid, and obviously he has not withdrawn and he has not died, the APC, their political party, does not have the right to change him. If the facts are the same, if the other gentleman in Akpabio, his nomination is valid or considered valid or upheld as valid by the court, definitely there is no way it will be submerged for the nomination of Senator Akpabio.
Okay.
So that is the only thing I may consider. Otherwise, any other thing is something that is unknown to us. Morally speaking, you may consider it inordinate. However, legally speaking, and there has been this argument back and forth that you cannot contest participate in two primaries in the same electoral period and all that. And people try to allude that to the provisions of the Electoral Act, but especially section 115 or thereabouts. And I've tried to look at that, and I don't see that being the case. You know, there is no specific or express provision prohibiting such moves. So to that extent, legally speaking, I don't think they've done anything illegal. It's probably morally, you know, to the fact that some other person had, you know, all the while participated and aspired to a particular position while you were on another lane, you know, as you may say, aspiring for another position, and then just because you lost in yours, and then you step back to now start over, is okay. That is just what it is. Political parties, both in the Constitution and the Electoral Act, play very vital and significant role in the electoral process. They are up there with the electoral umpire, so, and then electorate, in terms of determining the credibility, fairness, and otherwise of the political and the electoral process. But unfortunately, over time, our political parties have been found wanting. In fact, they seem to have penchant to observe the law in default, because one of the very clearest laws we have in our country is are the electoral laws, starting from the Constitution and then the Electoral Act, and they are very express and clear as to what should be done by who. In this case, political parties, their roles are very clearly spelled out, especially in respect of nomination of candidates, and this nomination has to be through party primaries, and even the Electoral Act also spells out the procedures that have to be properly followed through in the conduct of the primaries. But for want of integrity and political uprightness, our political parties are still very far away from this. And if they play by the rules, I can tell you most of these individuals will definitely sit up and not think of indulging in such acts, which we just have stated we have to be moral, probably because the Constitution, the laws will not provide for everything